agreements with third states. The floor is yours.
Thank you very much, dear colleague, and thank you also for this kind invitation. I also very much appreciate for your understanding, so that unfortunately I couldn't attend the great conference that you organized in March this year, but I have now the privilege to share with you my research. This is part of my research that's basically followed up quite a bit on my dissertation, and it's of course linked with the European Union external relations law, which is my main specialization. So please allow me to share my screen. I have a short presentation for you that might also help for the Q&A session afterwards. So I hope that you can see it. Wonderful. So okay, so my today's presentation is entitled as follows: Institutional Challenges in European Union Trade Agreements with Third States. When I read again the title of my presentation, when I was preparing this speech for you, I questioned myself, why did I limit myself to European Union trade agreements? Actually, the answer will be quite simple to this question, is mostly because since 2009, more or less, after the entry into force of the Treaty of Lisbon, the common commercial policy of the European Union changed dramatically. And not only the European Union concludes now free trade agreements of a very comprehensive nature, which are called the new generation free trade agreements, also other arrangements that the European Union concludes with third states, like for example with Switzerland, or when it concludes international association agreements with the Ukraine, for example, or Turkey, it also has not only huge trade dimension, which is quite normal because, as all of you know, and as we were well taught as European Union students in our student years, the European Union integration project is mostly about free trade. So of course, in all these comprehensive arrangements, trade arrangements, association agreements, institutional agreements, you will see what I mean in a couple of minutes, basically have same challenges. And I will call them institutional challenges. But again, following different agreements that the European Union concludes with third states, those institutional challenges are differently named. Sometimes we call them institutional arrangements. Sometimes we call them governance issues, if you think about Brexit arrangements. But more or less, the main problem and the main issue for third parties is always the same: what to do with the Court of Justice of the European Union, and what is the role of the Court of Justice of the European Union in international deals that the European Union concludes with the rest of the world. So it's a quite problematic issue, because if you think of that from the perspective of the European Union law, it seems very easy. We have the huge jurisprudence of our Court of Justice of the European Union on the specific nature of the European Union legal order, on the autonomy of the European Union law, and of course on the role of the Court of Justice of the European Union, which should be huge according to the European Union legal system. But if you place yourself from the perspective of third states, this is quite problematic. I used to live for 10 years in Switzerland, and for my 10 years of living there, there was one and the same problem. We need to conclude an institutional agreement with the European Union in order to deal with potential problems that Switzerland can have with the European Union. And it was a huge challenge, because the problem was always the same. European Union wanted Switzerland to be subject to the jurisdiction of the Court of Justice of the European Union, and Switzerland was not willing to do so. It's like, for example, for Switzerland, it was like to place itself in such a situation that, for example, a Tribunal Fédéral, which is the highest jurisdiction in Switzerland, would have had a word in all international deals with the European Union. So that's how the role of the Court of Justice was perceived from the outside European Union legal system. And I want you to see the points. It's quite problematic in international law when one of the parties tries to place its jurisdiction on the top of the international arrangements it tries to establish with the third states. So, and we will try to see why it is problematic and how to deal with this issue. So my first question that I would like to discuss with you is actually, is there an institutional model for European Union international agreements? So you see here, I'm a little bit broader. I'm not talking only about trade, even though you see that the silver lining of all international agreements of the European Union with third states is trade, mostly, not only, but mostly. But here I try to be more inclusive. So what is the institutional model? Is there an institutional model for international agreements that the European Union concludes with the rest of the world? When I was reading and analyzing academic literature in the case law, mostly of the Court of Justice of the European Union, to answer this question, it appeared to me that there is no really model-based approach. Even if we try to design some kind of model, for example, if it was the case, there was a huge debate during Brexit times. So how to design the institutional arrangements for the withdrawal agreements, for the trade and cooperation agreements, which is now the future relationship, the current relationship agreements with the UK. And it's appeared that it's quite difficult to adopt one model. So the easiest conclusion here is that the European Union basically has to proceed on a case-by-case basis, and I will show you why. So my first part of this presentation will be to basically to show that there is no institutional model. And actually, it's quite difficult to talk about a model because it's simply in existence. Whether my second part will try to establish criteria. What are criteria that the European Union and especially the Court of Justice of the European Union tries to promote in order to design different institutional arrangements with the different treaty partners? So what are those criteria and how to measure the role or the absence of role of the Court of Justice of the European Union in these national agreements? So no, there is no a model-based approach because each case is very special. So let's take the first case that you can see on my PowerPoint and with which I'm very familiar. It's basically the deal between European Union and Switzerland. So the relationship between the European Union and Switzerland is a very peculiar relationship. More or less 70s, it was in 1972, there was one big free trade agreement concluded between the European Union and Switzerland. Since 1972, there were more than 100 agreements concluded between the European Union and Switzerland. That's too many agreements, and it's quite surprising from the European Union why such a big organization as the European Union would conclude different sectorial, as we call them, agreements with a small country, Switzerland. The answer is very simple. It might not appear so, but the answer is actually quite simple. It's simply because Switzerland always promised to the European Union, and promised, I use it in a political term, it's not a legal appreciation. Switzerland promised the European Union to join this integration project from the very beginning. And there was even a demand on the accession that was sent by the Swiss government to the European Union and was basically on the European Union negotiation table for a couple of years. But then it was withdrawn, and the issue of accession of Switzerland to the European Union was never raised anymore. But the very fact that there was an idea of a potential accession of Switzerland to the European Union made it possible for the European Union to conclude all the sectorial agreements with Switzerland. It's basically some kind of association, but not in one single agreement as the European Union is usually proceeding, like, for example, with the Ukraine, as you know better than I do with Turkey as well, but it's a set of agreements on different sectorial issues that the European Union concluded with Switzerland. But what was the problem of this difficult relationship is that in each bilateral agreements concluded between the European Union and Switzerland, there was neither one homogeneous institutional arrangement established. So we had different types of legal arrangements. For example, in one agreement, we would base the whole agreement on European Union law and on dynamic adaptation of this law. In other agreements, it would have been static European Union law that would have been referred, or some other agreements would simply refer to law of the parties or international law. So there was no one specific institutional framework that would have been established in this difficult type of cooperation. And at some point, European Union just saw that Switzerland doesn't want to be a member state of the European Union. And since 2013, more or less, European Union started to ask from Switzerland to adopt one institutional framework, at least for agreements that grant access to the internal markets of the European Union. Because Switzerland is also, we don't mention this enough, but Switzerland is a full member of, okay, let's say more or less full member of the internal market, but especially it respects the four main freedoms within the internal market of the European Union. And there is especially free movement of workers, and Switzerland is part of free movement of workers with the European Union. So of course, for this type of agreements on free movement of citizens, workers, or etc., it is extremely important to establish some kind of institutional guarantees for both parties. And that's what the European Union is asking from Switzerland for more or less 10 years. And an agreement was reached in 2018. And for political reasons, we will see it later on, it was never adopted. So we don't have a homogeneous institutional framework for Switzerland-European Union relationship, and it is problematic. Then we have another model. You see, it's not really a model, it's a case-by-case approach. We have European Economic Area Agreements. So this agreement is basically free trade agreement, and especially it grants access to all EFTA states. So Norway, Liechtenstein, and Iceland, without Switzerland, to the internal markets of the European Union. So EEA, it's basically the access to the internal markets of the European Union of those three states. And this type of agreement is institutionally well developed from the perspective of European Union law, because there is the whole chapter in this EEA agreement that establishes how dispute settlements should be dealt with if there is an issue of interpretation or a problem between the parties. And in Article 111 of this EEA agreement, there is a possibility to both parties to basically ask questions to the Court of Justice of the European Union if there is an issue of interpretation of same provisions in these agreements that those that one can find in European Union law. Okay, so there is this possibility again granted to the Court of Justice of the European Union to interpret basically not European Union law per se, but copy-pasted European Union law within the European Economic Area Agreements. So why I make this difference? It's extremely important, this nuance. Even though the European Economic Area Agreement is based almost entirely on European Union law, it's basically copy-pasted European Union law. The nature of this law, the rationale is not the same. If you think about European Union law, the aim is to create an ever-close union among peoples of Europe. But when you try to find out the rationale of the European Economic Area Agreement, it's free trade. It's mostly integration within the internal market. It's not this global aim, this more deep rationale to create a closer union among peoples of Europe. And for this reason, even though the law is drafted in the same way than European Union law, the rationale and the raison d'être of this law is not the same. So this nuance is important, and it is also made clear in the case law of the Court of Justice of the European Union. Then we have the case very extensively discussed in academic literature of the European Union and the UK relationship. So we know that there are two agreements, even though the withdrawal agreement is not applicable anymore. There are a couple of chapters that are still producing the legal effect until now, and where the Court of Justice of the European Union basically has a word to say. So we still have a very limited span of law within this withdrawal agreement, which is not applicable, transitional period is over. But because there is some kinds of sunset clauses in a couple of European Union law, we still have the jurisdiction of the Court of Justice of the European Union as follow-up of this withdrawal agreement. But what is interesting is that in this new agreement, which somehow establishes a current relationship between the European Union and the UK, so this TCA, Trade and Cooperation Agreement, we don't have any role whatsoever for the Court of Justice of the European Union. And this was the agreement reached at the very last moment, so let's say 2 minutes before the deal was signed and established. Negotiators agreed that there won't be any role for the Court of Justice of the European Union. It was a huge progress for the UK, but a big loss for the European Union, because even though this agreement, the idea of negotiators, especially from the UK side, is to design some kind of free trade agreement plus, so you know, the agreement concluded between the European Union and Canada, which is free trade agreements without any role for the Court of Justice of the European Union. That was the model for the UK negotiators. But you can imagine that the UK is a very special case for the European Union, because most of legal substantive law on different trade arrangements, etc., it comes from the European Union legal order. So, and even though we have this great bill incorporating all European Union law within the UK legal order, it's still somehow European Union law. And for this reason, the European Union was very keen to establish at least the jurisdiction of the Court of Justice of the European Union for interpretation issues. But it was not the case. And in this TCA agreement, there is no role whatsoever for the Court of Justice of the European Union. And it was somehow unprecedented for the UK, which is a country, even though not member states of the European Union anymore, but which has very important links with the European Union. Next case are association agreements. If we think about two cases, for example, European Union-Ukraine association agreements, or it's called deep and comprehensive free trade agreements, but it is more or less the same legal basis than association agreements of the European Union. And for example, the agreements between the EU and Turkey from 1963, there is a role for the Court of Justice of the European Union. It has the jurisdiction on the interpretation of European Union law. So if there is an issue of interpretation of European Union of norms coming from the European Union legal order, the Court of Justice has its jurisdiction. And finally, another type of agreements, like purely European Union trade agreements, and I think about CETA or European Union Singapore agreements. In those agreements, they're not based on European Union law, and they are not even provisions of those agreements don't produce direct effect on individuals or economic operators. So for this particular reason, the jurisdiction of the Court of Justice of the European Union could have been avoided. So that's why it served somehow as an inspiration for UK negotiators when they negotiated the TCA. So you can see from this general question that I had in my mind when I was thinking about this, my paper and the presentation, is basically that we can't really talk about a model for institutional arrangements that the European Union proposes to its international partners. We can find a political science and legal literature on external differentiated integration, where one can see how the role of the Court of Justice of the European Union is differently approached in different type of agreements. And I think that it makes total sense when one can try to find criteria when and how the role of the Court of Justice of the European Union is important or less important in international relations of the European Union. And we will see it later on. So now that we have seen that there is no model-based approach, what we are talking about when we are talking about institutional arrangements. So the simplest answer would be, what is the role of the Court of Justice of the European Union? And it's basically everything is turning about this particular idea. But one also used to talk about three types of elements that are part of institutional arrangements, which are supervision mechanism. So we need to see how the agreement is applied and whether parties apply the agreements correctly. So this is the supervision mechanism. Then we need to see also what is the law applicable to the agreement and how it is updated. So as we could see from, for example, EEA agreements or European Union Switzerland relationships, the law is mostly the law of the European Union. So all these international agreements are based on European Union law and how it is evolved. But sometimes agreements are simply based on international law, like European Union trade agreements. So, and in this particular type of agreements, logically, there is no law for the Court of Justice of the European Union. So that brings me to the last to the last component of this institutional arrangement, which is the dispute settlement per se. So how to treat dispute, what is their jurisdiction responsible for the disputes between the parties, etc. So now that we have identified what are institutional arrangements without a model-based approach, we need to find at least somehow systemic criteria for different institutional designs that the European Union offers to its treaty partners. And here, because my field of expertise, it's easier for me to share with you how it was designed with Switzerland. First of all, this institutional framework that was proposed to Switzerland in 2018. So you remember that there is this framework of, there is this, let's say, network of 100 plus agreements between the European Union and Switzerland. And the main idea and the main demand from the European Union side was to establish at least one institutional framework for agreements granting access to the internal market. So when we have an access granted to Swiss operators to the internal markets of the European Union. And for this reason, the main problem, and it's actually the main issue of the whole European Union integration logic, is that we need to apply the same law and we need to have the same kind of dispute settlement. So it's extremely basic idea. And for this particular reason, European Union demanded from Switzerland to at least establish an institutional framework for those agreements that are granting access to the internal market. And among those 100 plus agreements, only 5 or 6 agreements were identified. So this was the scope of the agreements on this institutional framework. You see, it's only to 5 or 6 agreements that this institutional framework was supposed to be applied to. Then, so you remember our, not classification, but what our main components of an institutional framework. It's also about the law. So as those agreements on the internal market access are based on European Union law, we need also to adapt them to the evolution of European Union law. And for this reason, there was an idea of so-called dynamic adaptation. So it would mean that all agreements between European Union and Switzerland granting access to the internal markets of the European Union would need to be dynamically adapted to the evolution of the European Union law, which makes sense because we want the same law to be applied to all economic operators. And for this reason, it was very important in the scope of this framework agreement to establish what is the relevant European Union law acquis relevant for those particular agreements. So you see, it's a very limited nature of the institutional framework for a Swiss-EU relationship. Then, and now we come to this dispute settlement arrangements. Dispute settlement arrangements within the European Union Switzerland institutional framework was mainly of 2 nature. So the first part of this dispute settlement arrangements was how to interpret law. And for this reason, there was a specific cooperation established between the Court of Justice of the European Union and the Tribunal Fédéral, which is basically the highest jurisdiction in Switzerland. So the main idea behind this cooperation was to make sure that both highest jurisdiction of both parties interpret and apply law in the same way. And then there was this second part of this dispute settlement arrangement, which was this inter-party dispute settlement. What happens if we really have an issue of how the law should apply? So, and we can't find an agreement between European Union and Switzerland, which is almost impossible. You know, the relationship between European Union and Switzerland is lasting for years, and they could find an arrangements all the time. And so this is highly hypothetical issue. And the idea was to establish two steps dispute settlement mechanism. So the first step is political dispute settlement. So we create these committees, this mixed horizontal mixed committee, comité mixte horizontal, and sectorial for each particular type of agreement granting access to the internal markets of the European Union. So the first step of any dispute settlement was supposed to be political. So on the level of the Commission from the EU side, for example, and on the level of the governance from the Swiss side, there would be an agreement of political nature that was supposed to be found. If no agreement found, there was a possibility to establish an arbitration. So an arbitration is a very common practice in international law, but the particular issue of this type of arbitration here is that the arbitral tribunal would have been granted the possibility to ask interpretation questions to the Court of Justice of the European Union. And here we have this, even though it's highly hypothetical, it's actually the third step within this dispute settlement mechanism. It was highly problematic for Switzerland. And just think about it. It would be problematic any external treaty partner, that the last word in any dispute, potential dispute settlements, would have been actually granted to the jurisdiction of one of the parties. It would mean that the Court of Justice of the European Union would be the only jurisdiction having the authority, the highest authority, to say what the law is. So, and of course, for political reasons and historical sensibility, if we are thinking about Switzerland, this agreement was abandoned, and so because of the lack of political consensus. But this kind of model that you can see here that was proposed to Switzerland in 2018, it's not very surprising. It's actually something very common as the European Union is offering to its external parties, external partners who are willing to somehow participate in the internal markets of the European Union. So as long as we have at least one element of participation, accession, cooperation with the internal markets of the European Union, we cannot avoid the jurisdiction of the Court of Justice of the European Union. Okay. So my second point, now let's try to see what are criteria for institutional arrangements in European Union international agreements. So how to find a way basically to avoid the jurisdiction of the Court of Justice of the European Union in different international agreements of the European Union. So the usual problem of justice. So, but the problem from the EU side, and how to please the difficult notion of the European Union autonomy. Because according to this narrative of the Court of Justice of the European Union, and the European Union legal order is autonomous, and especially the jurisdiction of the Court of Justice is extremely important, and it is the only institution which is supposed to be competent to interpret European Union law. And I'm thinking especially about a paper that was written by Professor Vestel and Joris Larik on the what are these criteria in order to avoid any type of violation of the autonomy of the European Union law. And basically the easiest answer is that any type of jurisdiction established in international agreements between the European Union and a third party should not have any words whatsoever on European Union law, its interpretation, or the role of the Court of Justice of the European Union. So what are main criteria when one thinks about different institutional arrangements in European Union international agreements? So the first thing that we need to really focus on is what's the law governing the agreements? Is it the law of the European Union? Is it international law or law of the parties? Okay, so here the simple answer would be whether it is European Union or international law. For European Union law, so think about the European Economic Area agreements, for example, or for international law example, think about European Union trade deals with Singapore or Canada. So the second and a very important question that one should ask when we are thinking about institutional arrangements, what is the rationale behind the agreements? If we are talking about an association, so this rationale is close to the integration idea within the European Union. So this is most likely that the rationale, the law within this agreement is somehow close to the law and to the rationale of this law within the European Union legal order. And here we have different types of rationale behind the agreements. So the association agreement is not same type of agreement than, let's say, the TCA, because it's a completely different type of logic, or it's not at all the same logic than we have behind European Union, Switzerland's relationship, etc. And of course, last but not least, we need to think whether in international agreements and its provisions have a direct effect on individuals and economic operators. And that would also determine what is the role of the Court of Justice of the European Union. So to summarize, again, this is my reading, and that's some kind of draft table that's I put on paper when I was writing this paper. We have different type of rationale, legal regime, and the role of the Court of Justice of the European Union. So you can see that every single time, especially I'm referring to the column 2 and 3, so legal regime and the role of the Court of Justice of the European Union. So you can see whether, if you see European Union law and access to the internal markets of the European Union, one cannot avoid the Court of Justice of the European Union. But when you see that it's only based on international law logic, so we are immediately within the normal jurisdiction that one can find in international, classical international agreements, which is an arbitration. So this was the main summary of my findings and of criteria that's, I think, are extremely important when one thinks about different types of institutional arrangements. So my main conclusion is that even though there is no model or there is no models for European Union institutional arrangements, one can easily find a systemic approach in EU comprehensive international agreements regarding different type of institutional settings. And for this, we just simply need to establish criteria. And main criteria that one can find for all of these institutional settings, since basically a rationale behind the agreements, law governing the agreements, which will determine the role of the Court of Justice of the European Union. To refer to the pan of academic literature related to the differentiated integration, one can see that's also something that I noticed while preparing this paper and presentation. It's extremely difficult to somehow establish a settlization around the European Union legal order. So closer you are to the internal market and to the logic of European integration, closer you are to all this logic of autonomy and the role of the Court of Justice of the European Union. So it was difficult for the UK to extract itself from the European Union legal order, and it's difficult for Switzerland, for example, to be as close as possible to the internal markets of the European Union without having this role of the Court of Justice of the European Union. So what also appeared from one of my main findings is basically arbitration plus Court of Justice of the European Union is somehow a compromise that the Court of Justice and the European Union proposes to its treaty partners. So it's something in between European Union law logic and international law. So we establish an arbitration, and eventually, if an arbitration tribunal has a problem with the interpretation of the European Union law, it shall ask a question to the Court of Justice of the European Union. So this is some kinds of this legal tricky compromise that one can find more and more in this difficult, complex legal regime that the European Union is offering to its treaty partners. So thank you very much for your attention. And if you have questions, I'm all yours.
Thank you, Professor Kaspiarovich, for this